Welcome to the PricePlow podcast. We have a very special episode today. We're honored to have Michael Goodman of Hudson Cook with us. Michael is a lawyer who is a regulatory expert, especially when it comes to the Federal Trade Commission, or FTC. Now, this is something we really haven't talked about on our channel today. And Michael has in the past, this is way long ago, reviewed some of the stuff on our website in terms of disclosing our sponsorships and things like that. So recently, the FTC sent out a lot of letters to various dietary supplement manufacturers, and we figured this is a good time for us to educate the audience in terms of FTC compliance. And so I brought him on, I invited him to the channel, and he graciously accepted. So thank you so much for coming, Michael. Can you please introduce yourself and your firm a little bit, and then let's get into some of the nuts and bolts about what dietary supplement brands and stores should care about in terms of FTC compliance, and maybe some stories about where things can go wrong.
Sure. I started out my legal career at the Federal Trade Commission as a staff attorney in their Bureau of Consumer Protection. I was there about 5 years, and then I joined Hudson Cook, and I've been here about 18 years. Most of my practice is in advertising compliance, and it doesn't have to be specific to any particular thing. From the work that I do, an ad's an ad, and I can review just about any kind of ad for FTC compliance. Basically, what I do is put myself in the shoes of the regulator at the FTC and look at an ad, talk to the client, ask questions, and try to make sure that we've mitigated risks of FTC scrutiny as much as possible. And then I also handle investigations for clients. If the FTC is considering bringing an enforcement action against a client, I can represent them in that. And again, that's not industry specific. That's just FTC specific. My firm does not do a ton of work with the people in your space, but you and I have worked together, and I enjoyed that. And again, with the work that I do, I can handle just about any kind of ad. It doesn't matter as long as we ask the right questions and think about it from the regulator's perspective.
Awesome. So our consumers kind of range anywhere from regular consumers all the way up to, we also have viewers from actual brand ownership, retailers that might be using ads to increase their business, or even maybe bigger stores like GNC Vitamin Shop, people like that. So to start off from a very basic point, could you give us just some kind of ground level rules for things that you're looking for in advertising? I think specifically we might want to think about influencer advertising or influencer marketing, as well as diet and weight management, or maybe muscle type stuff. But overall, what are some general things that you're looking for when you're looking from the regulator's perspective?
That's a great place to start. And if I go on too long, just wave your hand and we can break it up a little bit. But basically, the FTC enforces a very basic standard when it comes to advertising. It's a prohibition on unfair or deceptive acts and practices. And really everything the FTC does filters down to that one prohibition on unfair or deceptive practices. An unfair practice is one that's likely to cause substantial injury that consumers cannot reasonably avoid, and that isn't outweighed by countervailing benefits to consumers or to competition. The other standard is the deception standard. It's the one that comes up much more often in advertising cases. An act or practice can be challenged as deceptive if it's likely to mislead a consumer acting reasonably under the circumstances about a material fact. And so when the FTC goes out to the marketplace and looks around, those are basically the two standards that they have in mind when they're reviewing ads or other practices. What the FTC has done over the years, that the agency's been around over 100 years. And so it's had plenty of time to develop a body of law around that simple standard. And over time, the FTC has issued guides, policy statements. When it's identified an area where a body of law is developed and they can provide some more specific guidance, they have done so. And relevant to this conversation is, number one, the substantiation policy statement, where the FTC explained how it looks at the substantiation standard when it's reviewing advertising. And number two is the guide that it's issued on endorsements and testimonials. That second thing, the endorsements and testimonials guide, came out in the 80s before we had social media. There were always influencers, but not like we have today. And the FTC over the last few years has tried to modernize that guidance, which is now 40 years old, to try to make it more relevant today and to also help people apply it. Because when you read the guidance now and you're an influencer or you're working with an influencer, there needs to be a bridge between that old standard and what people are doing today. And the FTC has tried to help with that also.
Awesome. So I feel like there's so many different ways to take this, but I do think that the endorsement probably is the most important section right now. And we also probably should talk about how businesses themselves represent products, because that recent guidance, I think, has really been pointed at manufacturers, retailers, and even ingredient creators and how they sell their ingredients based on data they've created. So much of what we talk about in regards to the FTC comes down to like claims on actual products. And I think that this could really talk about either harming people, because these are things that are ingested, but probably most likely is much more about being misleading. So could you talk to us a little bit about what would be or what wouldn't be misleading in advertising for these products? Because things that come to mind for me most recently are like the Liver King issue, where you have someone who is so incredibly larger than life talking about a product that may or may not take you to his level. Or what are some things that you look for that are red flags in these kinds of areas?
Sure. Well, for starters, one thing that I do when reviewing an ad is just look for concrete claims in the ad and asking the client if the claim is true or not. And if it's not, then we go back and revisit that claim. And one of the things that comes up a lot is when clients like to make unconditional claims. If this product will deliver X result for you, without any kind of wiggle room for the fact that people's experiences may vary. And so a conversation I have with clients all the time is, you're making an unconditional claim here. Is it unconditionally true? And if it is, then it can stay. And if it's not, then we talk about ways to explain what the limitations of the claim are, or the conditions are. Consumers need to know that in order to properly evaluate the claim. That takes us to the substantiation policy statement. It's important for this audience, and it may not be intuitive what the FTC is getting at here. What the FTC says is, if an ad makes an objective claim, that is a claim that's capable of being supported by data or supported by substantiation, then consumers are going to think that you have support for that claim, proper support, when you make it. And it doesn't matter if your ad actually says studies show or doctors say. If you present an objective claim, if you use this product, you will get this result. The FTC's view is consumers hear that to mean you have support for it, whether you said so or not. It's implied there. And you need to have it when you make the claim. It's not enough to backfill your support later after you've made your claim. You need to have it in hand when you release your ad or make your statement on your website, whatever you do to tell the public about what your product is. And so the first key message for this group is, if you're making performance claims, you need support, and not just any support that the FTC would consider appropriate. And that would be based on what the industry considers appropriate. The FTC will ask, in this particular context, what are the reasonable expectations for proper support? Is that what you have? And that will be the expectation.
Okay, so it sounds like they're probably not going to like animal-based studies when you're making claims, though. Can that be assumed?
There's a great resource if you follow the FTC's letter that prompted this conversation. There's a link in there I can hold it up,
Awesome.
although it's backwards. Health products compliance guides.
So yeah, if you're watching on YouTube, we'll put it in the show notes for anyone who's not watching in the video on YouTube. We also have the audio feeds. So what was the title of that real quick?
Health products compliance guidance. and it's linked in this notice of penalty offenses letter that we that prompted this conversation. And what it talks about, it talks about animal studies in particular. This isn't a particular focus of mine in my practice, but I did read the guidance. And what it says is there might be times, depending on the product and the claim, where you can get away with an animal testing claim. If the burden will be to show that it's reasonable to rely on an animal testing support for your claim. And if the FTC thinks that that's insufficient, then you've got exposure under the deception standard that you lack proper support. It's really context specific and fact specific.
Okay, so thank you for answering that. So it does sound like a little bit is subjective. I wanted to get back to the influencer stuff though, because there's a couple different ways that influencers can be used. Like you have some, and so maybe you can break between these two, but you have, at least in the sports nutrition space, you have affiliates who get a coupon code at a brand. Use coupon code XYZ, you get 20% off. They get maybe a 15% commission. And then you also have influencers who are actually legitimately paid cash to actually post an Instagram video, we'll say. So there could be two different answers on this. I'm not sure if that matters or not. But let's say we have an influencer who is clearly on steroids, for instance, and goes and uses a product and says this product did certain things for me. This product helped me build more muscle. But it's pretty clear that this person's also using, substances that are beyond the dietary supplement. Is this something that the FTC would frown upon? And is there a differentiation? It's a two-part question. Is there a differentiation between just an affiliate who's going to get a commission and someone who's actually getting straight up cash from the company for making that video?
That's a great question. And the way the FTC looks at it, the main fork in the road is if somebody is out there making statements about your product, the fork in the road is, did you incentivize the person to talk about your product or not? And we'll get into the types of incentives, but really what matters to the FTC is, did your company go out to this user and say, if you say something nice about us, we'll give you a coupon or we'll pay you money? If so, you're responsible for what the person says, and you also need to disclose that connection. If somebody's just out there reviewing products without any connection to you, and they say something good or bad about your product just out there in the world, you're not responsible for that unless you have a connection to that person. As far as the type of incentive is concerned, it doesn't really matter whether you're giving someone money or a coupon or a discount. Anything that you could do where the way the FTC looks at it is, if the consumer knew about that relationship, would they evaluate the claim differently? If the answer is yes, then the FTC wants you to disclose that connection.
So basically a good rule of thumb is that if you're being incentivized at all to even share content, you should be disclosing that there is a paid relationship. Okay.
Yes.
Now, does the location of that content, like say if this person does not get incentivized at all, but then that brand uses that content in an advertisement or shares that, is that an endorsement of that there? And because they're selling that product themselves and they're using that, then that content then is again privy to this type of regulation?
Can you give me an example?
So for instance, I sell a product that, helps you lose fat, and someone who I don't pay buys the product, loves it, loses an exorbitant amount of weight, and shares online that this product will make you lose 50 pounds. I obviously think the video is awesome because it says really good things about the product that I create. And I then share that product or that video, but it's still a ridiculous claim to say, this will make you drop however much, because I'm now sharing that and I sell that product, even though I didn't pay this person. That's still a claim that really shouldn't be shared.
That's another good point. So there's nothing to disclose in terms of a connection between you and the user, but the FTC does say you're responsible for the content of a testimonial like that, whether you paid the person or not. If you went out and got that video and are now using it to promote your products and services, you're posting that video on your site, you're now responsible for the accuracy of what they've said. And so if they make a wild claim, you can't use the video, or if the wild claim is that they had an unusually positive experience, you can still post that video if it's accurate, but you need to disclose what the typical or generally expected performance would be. It used to be you could put something up there that said results not typical. But the FTC found that was an ineffective disclosure, and people weren't picking up on that. And so they revised the guidance to say, you now need to disclose what the generally expected experience would be if your testimonial is an unrealistic experience. Something that I think
that's cool. Yeah.
Something I think advertisers get wrong is that some people feel like, well, if my customer said it, I didn't say it, I should be able to just put it up there as a satisfied customer, what they said. But once you bring it into your world, under your control, whether it's on your website or in other marketing material, the FTC is going to hold you responsible for reviewing what the statement is, determining that it was true, and that it was representative of other people's experiences.
Okay, thanks. So one thing that we see a lot of times, we deal with FDA regulations, and one thing that we see a lot in our industry is that there's not a lot of enforcement. We see a lot of products that are made, maybe at least in smaller runs and smaller companies, everything, a lot of products that are clearly not fully compliant per the FDA's guidelines or per what Congress wrote in 1994. And so a lot of like smaller brands basically get away with certain things that a larger one wouldn't get away with, or wouldn't even dare to try to get away with. I'm wondering, like, do you see a similar situation with the FTC? Like, there are so many small brands in every industry, supplement industry or whatever other industry it is. Is there a lack of enforcement sometimes, or like, what is the risk ratio here? And I'm wondering, like, if there are any like good war stories of times where smaller brands maybe have gotten hit by the FTC, if it's kind of the same with what we see with the FDA.
That's a tough one. The FTC certainly has many more potential targets than they have resources to go after. And so I'm sure you guys hear this, and I hear it too, where people say, well, you're telling me not to do this particular thing, but look at these 20 websites that are all doing that thing. Why can't I do it too? They're making claims, there's no disclaimer, so why can't I? It must be fine. And the reality is more likely that the FTC just doesn't have the resources to go after everything that would violate the FTC Act. So it may be the case that your risk of getting caught is low, but if you are caught, your risk of getting in trouble is high. And so the risk you're running is anyone going to notice that I'm out there? And it's hard to predict. The FTC has leadership that changes over time. Congress has priorities that change over time. Right now, privacy is a huge issue. I don't know if dietary supplements get the same attention right now that other issues do at the FTC. But as someone who works on enforcement actions, if you're one of the unlucky people who gets picked to be the target of an investigation, all the advantages that you had for yourself in flying under the radar go up in a puff of smoke, because it's so burdensome and expensive to be the subject of an enforcement action, that I want clients, and I would want your listeners to be concerned enough about that bad outcome to take it seriously. Because if you may be unlucky that you get picked, but if you are picked, then your next 2 years are really rough and really expensive.
So we definitely want to get into privacy. I think that's something that Mike and I both share an interest in, and I think that's a really important topic. But before we get there, in terms of, we touched on social media and things have changed. I'm actually super curious about what the FTC was doing 100 years ago, because 100 years ago, I assume it was just pretty much newspaper ads. But with the advent of social media, advertising, whether it be through Snapchat, Facebook, Instagram, whatever, there are a lot of very large companies that are reviewing ads before they go public. Is there any sort of cooperation between these types of large companies in terms of and kind of being an intra-industry enforcement or a first line of defense to stop these kinds of issues? Or how has that worked into the whole kind of ecosystem of this?
Well, I know in some markets, Google, for example, may prohibit advertising for certain kinds of businesses, and they may prohibit certain types of claims, especially in the credit world, where my firm does a lot of work. So there isn't like cooperation between those kinds of internet marketplaces and the regulators, but those marketplaces can be a first screen to look at an ad before it goes live. I don't know that I would rely on that review to take the place of the review that I think each company should do for its own advertising. But I have seen cases where Google has just said, we're not running this because it's a market we don't allow people to advertise, or it's a claim we don't allow people to make.
Gotcha. So,
okay. You mentioned enforcement actions. I would love for you to walk me through like an enforcement action. What happens? You get the certified letter from the FTC, and then it's like time to lawyer up. Is that when you oftentimes get contacted? And it sounds like a 2-year hellish process. So can you walk us through kind of how that all goes?
Sure. The typical investigation begins with what's called a civil investigative demand, which is like a subpoena, and you're required to comply. You can try to get out from under it, but you'll lose, and you can't just blow it off because you'll lose then too. And so once you receive one of these things, you have to suspend all your document destruction processes and start to retain everything. And then you have to work through their requests for information and respond to them. There are a couple different categories of requests that they make. One is called an interrogatory, which is like a question that you respond to with a narrative response or data or a spreadsheet. It's information. And then there are requests for documents where the FTC says, give us all your lead generator agreements. If you have affiliate networks, like give us all the relationship documents. And the biggest burden there is they'll almost always ask for emails or other communications. And those can be massive amounts of information to work through. Not all of it's responsive, but someone's got to look through it all and pick out what's responsive and what isn't. And that takes a while and costs a lot. These CIDs can also request testimony. So you'd have an investigational hearing where a company representative would be put under oath and a court reporter would be there, and the FTC would spend the day asking that person questions about the business. And these CIDs can also request reports where you have to take data, put it together, and answer the FTC's request for information in that form. Typically, the FTC will give you 30 days to respond. It helps to have a lawyer who is familiar with the process because you can sometimes negotiate how much time you have to respond and get yourself time extensions. You can break the CID into parts and respond in waves so you don't have to do everything at once. And you can also sometimes successfully get the FTC to narrow the scope of a question or of a CID and say, what you're asking is massive. I think what you really want to know is this smaller thing. So why don't you just ask for that instead of this massive request? And you still get the information you're looking for. After that, there's typically some downtime while the FTC processes all that information. And then typically the FTC finds something that they think is unlawful, and you pivot from the investigation to the implement process, which begins with settlement discussions, where maybe you can resolve it without going to court. That's typical. Or you can't, and then the FTC sues you, and then you hash it out that way, which is another couple of years and a lot more money.
So what you're describing here sounds like a lot of money just in general for the FTC. There's a lot of people involved, a lot of time. I guess my question for you is, you're talking kind of previously about like risk management and whether or not people will get picked. It sounds to me like this whole situation, it costs the FTC a lot of money. They must be going after companies and brands that are making a lot of money off of these unethical business practices. Would you say that like most of these situations are going after large scale companies? Because it seems just like to employ the people to do this investigation would cost a lot of money itself.
That's
I'm not
true.
sure they're a profitable business though, but yeah.
They don't have unlimited resources, but they don't feel the same. They don't do the same cost benefit analysis as a private company does. They're not as afraid to lose as a company might be. Their exposure is not as great. In terms of how they use their resources, it's not always the biggest companies. They have a few different motivations. One is to go after the companies that are doing the most economic harm. And that could be a smaller company that's basically a scam, that could be prosecuted criminally if there were resources for that. There are times when the FTC is just the government's best option for stopping a fraud because the Department of Justice has other fish to fry. So the FTC will come after you for civil relief rather than criminal relief. And that's where you tend to see them going after the smaller guys, is the ones that are just true scammers. And so the FTC wants that level of the marketplace to be concerned about an FTC action. And then there are also times when the FTC will bundle a group of cases together. Each one might be on the smaller side, but they're hoping that by packaging them together and announcing them all at once, which they call a sweep, that they'll get more attention for that, and get more deterrent effect out of it if they bundle everything together.
Okay. So kind of this is reminding me of something that happened last year that I wanted to bring up during this podcast. I'm not sure if you're super familiar with it, so please let us know if you're not. But there was a group called TINA, Truth in Advertising. I assume you're familiar with them, who came out with their own sort of sweep where they named, I think, 40 brands in energy drinks that were marketing and branding with candy and colors and all sorts of assets that had they felt were marketing to children, which they found to be harmful, or misleading, or whatever. A lot of different reasons why the FTC might be involved. But my first question is, how often does the investigation actually start from the FTC, or would it sometimes come from these maybe trade groups? And is advertising to children part of something that the FTC would deal with?
Those are good questions. The first question about the source of the enforcement action, that can come from a lot of different places. When I was at the FTC, one of the issues I worked on was email and spam. And the chairman at the time, her mom got a suspicious email, and that she gave it to her daughter who was running the FTC. And that sort of filtered down to the staff to take a look at this. And so it can be that sort of anecdotal, informal FTC awareness. It can come from Congress saying to the FTC, this is something we care about. We'd like to hear what you've been doing in this area. So that will launch an initiative, just because FTC wants to be responsive to Congress. The FTC has a massive complaint database where consumers can just submit a form, and it's searchable, and the FTC can look for trends, and they share that database with other law enforcement agencies at the federal and state level. And that's a common source of targets. Is if consumers are telling the FTC, this is something bad that's happening, and it reaches like a critical mass of complaints, then the FTC is going to say, all right, this is more than just noise. Let's take a look and see what's going on here. And it can be from competitors. Competitors don't often like to report on each other because they're worried that they're also sticking their neck out by just telling the FTC they're out there. But it happens, and same with trade groups. It's just, in my experience, people weigh I'd like to tell the FTC about this bad thing that's happening. But on the other hand, I'm worried that could wind up rebounding to me, and they'll take a look at me too and may not like what they see. Um, my sense is more often than not that scares people off from reporting on their competitors, but it happens. Oh, and then the second thing was on children. The FTC does spend some time on that. There's a law that's called COPPA, which is about privacy of children's information in particular, that the FTC has. There's a rule that they've come up with from that statute that they enforce about how companies can collect and share and use information on children. As far as marketing to children is concerned, the FTC can go after that as a specialized category. And a long time ago, they did a lot more of it. But in the late 70s, early 80s, there was a feeling in DC that the FTC was overreaching in terms of going after conduct that really didn't seem that bad, but the FTC was treating everything like an emergency. And Congress smacked them down budget-wise and said, you need to rethink how you're using your authority. And it's not on things like breakfast cereal being advertised on Saturday mornings. Like, that's not how we want you to be spending people's money. So revisit what you're doing. And so as far as energy drinks and things, I would say, like with e-cigarettes and things that have had a connection to children that people haven't been happy with, I would say unless there's that kind of health connection where this is really a product that kids should not be using or being encouraged to use, outside of that, I wouldn't expect the FTC to do much with the fact that it's to children. It's just, if there's something about it that's harmful to children in particular, then yeah, that's something the FTC will pay attention to.
Cool. Yeah, it's an interesting case because there are some energy drinks that have like video games. There's collaborations happening where you have like authentic collaborations of like a Tetris video game on the can of an energy drink. And is that marketed to kids, or is it more like going for the nostalgia effect because Tetris is really for older people at this point? I don't think most like young kids are playing Tetris as much. So that was kind of the interesting that happened there. Now you had mentioned privacy. This might not have much to do with the supplement industry, but before I get back into some supplement specific stuff, I'd like to know just what you think about what's the hot topic right now with privacy. And I assume like social media collection of your information, all that. But yeah, if you could share kind of the hot topic in privacy, I'd love to hear about it.
I think what the big topic is there is companies that are monetizing consumers' data in ways that consumers don't understand. So a consumer gives information to a company they do business with, and that company turns around, packages it, and sells it, and the consumer has no idea that that's happening. I think that's something that's of particular concern to today's commission. It's not always an FTC Act violation to do something with consumers' data. But my sense is when the FTC hears about that kind of data monetization, then their first thought is, do consumers know about it, and did they agree to it, and do they understand it? And there are plenty of cases where those answers are not favorable to the company. I think it's common for people to have no idea how their data is being packaged and sold and used, and this commission is concerned about that.
Okay, thanks. So let me bring that to PricePlow. Then we have not a huge list, but it's a decently sized list of users who follow hot deal alerts, but then they specifically follow brands or categories. So let's say I have like 8,000 users who are following the pre-workout supplements category, and so if there's a new product, they get alerted about it. That's kind of how our system works. However, when they signed up, we said that we were not going to sell their email addresses. And trust me, everyone, I'm not planning on ever doing this or anything. But sometimes a company gets sold, or sometimes there's a change in leadership and they want to start monetizing that data. What is the process for that to happen? Is it like, are they able to do it at all? Or do they have to send out like a new opt-in? Or like if I wanted to sell my pre-workout list, and I'm not, but I just like, as an example, how would a company go about that? Or can they just simply not do it?
Well, from the FTC's perspective, you're bound to your privacy promises basically forever. And once you've said, this is what we do and don't do, that's your commitment. The way to change is to get new permission from your users, including people who are your users under the old structure. If you want to do something new with their data, you should go back to them and get their opt-in to it. We've made a change. Do you want to be a part of it? And then retain a record of that consumer saying yes. But the FTC has brought cases where, say, a company maybe has gone into bankruptcy and they want to sell their customer data as an asset. But if they've said previously, we will not sell your data, then they're barred from treating it like an asset. And they're not able, just because the circumstances have changed, doesn't mean their promises are no good.
Thank you. Good. That's actually what I want to hear. So good to hear. Okay, so we can't have a supplement claims type of discussion without getting into 2020, COVID, all the things that happened over the last few years. Obviously,